Hello, everyone. This is Randy Clough from MCOL, and I would like to welcome you to our webinar event today, ACA Plan Sponsorship Roadmap for 2015. Our speaker today is Ashley Gillihan, Counsel, Alston and Bird. Before we begin, we do have a few housekeeping items to cover. If for any reason you experience technical difficulties with the web portion of today's presentation, please print off the PDF version of the presentation that was included with your dial-in instructions. The link is www.healthwebsummit.com/ACA-compliance101014.pdf. Our speaker will be taking questions today using the live chat feature. So now and at any time throughout today's web presentation, you will welcome to submit your questions. As always, if you require any other assistance, please contact the Healthcare Web Summit office at 209-577-4888. We are now ready for our speaker to begin.
Great, thanks. Thanks, everybody, for being here. Let me lay the groundwork of what we're going to talk about today. We only have an hour. We are going to leave some time for questions. So we're going to try to run through these slides, of which there are many very efficiently, some of which we won't cover. In fact, prior to the call, we had a little chuckle in the green room where I was reminded, based on the number of slides that I had, that we only had an hour today. But I promise you we'll do our best to get through the very important ones. Now, look, here's how we're going to go about this and what it is we're going to cover. Today, we're going to talk about those Affordable Care Act items that employers need to be considering as they move into 2015. Some of these are rules that are already in effect, but we're going to talk about them in terms of how they need to be viewed going forward. And what I will try and do, and if we do this successfully, you'll have this at the end, is to give you a high-level overview of some of these requirements and then hit on some nuances so that at the end of this, all of us together have a better understanding of what employers who sponsor health plans are facing in the future. It doesn't matter about the size of the employer, and we're not going to focus but just a few minutes on the employer shared responsibility provisions, which are limited to employers with 50 or more full-time equivalents. We're going to talk about things I think will affect all employers regardless of size, regardless of whether they have fully insured or self-insured plans. So let's jump in and start hitting some of these issues. Now, if you have questions per the instructions at the beginning, let's see, get these, there we go. Please submit those, and we're going to hopefully leave about 15 minutes at the end to address these questions. So let me do some legal landscape level setting for today. And this is probably one of the most important slides from a high level that we'll actually talk about today. The ACA, the Affordable Care Act, has many parts. It has been my experience over the last few years since this law was issued that employers, even service providers, tend to approach the Affordable Care Act as one big bill, and that is a mistake. You have to treat the Affordable Care Act as many separate and independent bills because the rules within each independent quote-unquote bill or section, if you will, differ. Certain rules apply to certain plans in one section, whereas they don't apply to certain plans in other sections. And it's important that you approach it and understand the various sections or categories of this bill and know the rules of each one in order to have an effective strategy going forward. So here's how I've broken them out. We're going to touch on these, each one of these, as we move along. So the first are the health insurance reforms. These are those rules that were added to the HIPAA portability subparts of ERISA, the Code, and the Public Health Service Act. And they included rules such as if you offer dependent coverage, you must offer coverage to dependent children up to age 26. No annual or lifetime dollar limits on essential health benefits. The requirement to issue a summary of benefits and coverage. I'll go over more and we'll be able to identify a few others here in just a few moments. But those reforms apply to almost all group health plans except plans that are accepted benefits and plans that cover only former employees. regardless of the size of the plan sponsor. And so that's one category, and you have to know those rules and the plans to which they apply. And then you have the individual mandate. Now, from an employer's perspective, it might seem counterintuitive to consider or think about the individual mandate. But as an employer who's offering coverage, you want to know that your coverage will be sufficient enough for your employees and their dependents who are covered under that plan to satisfy that individual mandate. And so you have to know what type of coverage will actually do that. How about the exchange, the individual exchange? Again, like the individual mandate, it seems counterintuitive for an employer to think or consider about the rules of the exchange. But time and time again, I see employers, service providers that have misunderstood the rules, and it has affected plan design. We're going to talk about some of those rules, in particular the impact that an offer of coverage from an employer may have on both your ability to participate in the exchange. Just as a hint, it doesn't affect your ability, and also on receiving a subsidy in the exchange. And there, an offer of employer coverage or being enrolled in an employer plan will affect your eligibility for a subsidy, not your ability to participate. And of course, we have the ever popular employer shared responsibility requirements. And again, you have to know there what the rules are and how they're applied. You know there that unlike the health insurance reforms, which apply to almost all plans regardless of the size of the plan sponsor, here this is not even a plan requirement. It's merely rules that impose excise taxes on employers who have 50 or more full-time equivalents who fail to offer certain coverage to their full-time employees. It's not a mandate to provide coverage. It provides no right of action for a full-time employee to receive coverage. It simply gives you the formula for calculating excise taxes that you may owe, if any, for your failures to offer coverage to full-time employees. And then you have taxes and fees, and this is where the transitional reinsurance fees and the PCORI fees, the health insurer fees all come into play, and there are many of them. And it's here where you really start to see where this point that I'm making with this slide, that you have to know the various sections, they're really underscored with the taxes and fees. For example, transitional reinsurance fee, I will pay on certain coverage offered to retirees. So retirees, at least those under age 65, that are covered under an eligible employer-sponsored plan that provides minimum value, I'm going to pay a fee for those individuals covered under that plan. But remember, the health insurance reforms, they're not applicable to standalone retiree plans. And so it's really here where you start to see and understand why we need to know the different sections and the rules in those sections. And then you have miscellaneous. I think I just lack creativity here, but these are rules such as the health FSA limitation, annual salary reduction election to $2,500, and various other rules that go with that. And so if you can approach the Affordable Care Act, even at this late date, I mean, we're obviously years into the Affordable Care Act, but if you can approach it looking at it not as one big bill but as separate sections and really get a handle on each one of these that I have on this slide, I think you're going to have a better understanding of the rules, which we continue to develop every day, and be able to design strategies that will help employers, help your company, if you're here in an employer capacity, approach this and have a smoother path along the way. All right, well, let's talk about each of these a little bit. These are the health insurance reforms, and for your reading pleasure later, you can get into looking at each one of these. But let me tell you how I've set this up. Health insurance reforms, there were some that applied to plans that were called grandfather health plans, and there were some that didn't apply. On the left-hand side, I have requirements that did not apply to grandfather plans. So if you're still a grandfather plan, you can ignore the left side. On the right-hand side are requirements that apply to all plans, whether they're grandfathered or not. The italicized versions are those that were effective for plan years beginning on or after January 1, 2014. If they're not italicized, they were effective plan years on or after September 23, 2010. Let me point out just a few of these, all right? So let me start with cost-sharing limitations on the left-hand side. So if you are not a grandfathered plan, there are limitations on your out-of-pocket maximum you establish under the plan. And for 15 plans can no longer have a separate out-of-pocket maximum for prescription drugs and medical. You can have separate maximums, but together the aggregate maximum out-of-pocket for both medical and prescription drug expenses cannot exceed the maximum that's been set forth in the rules. Also, we just got guidance right before this call came out on reference-based pricing arrangements. The DOL has previously issued guidance on the extent to which plans that don't have a network, plans that are setting either an allowed amount based on, for example, Medicare Plus percentage, or are agreeing only to pay a fixed fee for certain services, then if you have one of those arrangements, the extent to which amounts over and above what the plan has set, either as the allowed amount or the fixed fee, have to be counted towards out-of-pocket maximum. And they issued guidance today that would pave the way to some extent for those types of arrangements, but impose some administrative requirements in order to have those. On the right-hand side, I want to remind you about the lifetime and annual dollar limit prohibition on essential health benefits, and indicate that self-insured plans do not have to provide essential health benefits. However, if they do, they cannot impose an annual or lifetime dollar limit on those benefits. How do you determine, as we head into 15, this becomes very critical, even though this is a pre-existing law that's been in effect since 2011 for most of you, how do we go about this going into 15? Go to your plan. If you're a self-insured plan, go to your plan, look at, find the benefits in your plan that impose an annual dollar or annual or lifetime dollar limit, and then you find a benchmark plan in any state. HHS has all of them posted. If you can find a plan that excludes all or most of those benefits that you have annual or lifetime dollar limits on, then those benefits that are excluded by the benchmark plan, well, they're not essential health benefits, and you can keep those annual or lifetime dollar limits. And you can pick any plan even if you have no nexus to that particular state. But those will have an effect, and here's the key that I want to don't get caught up in these rules and the rules under the employer shared responsibility requirements. These rules, again, are applicable to all plans other than accepted health benefits, and we're going to talk about what those are here in just a few minutes, and plans that are limited to former employees, like we typically call them standalone retiree health plans. It doesn't matter the size of the sponsor. So you may have less than 50 employees. Your plan still cannot impose a waiting period, for example, in excess of 90 consecutive calendar days. So again, starting to underscore why we separate these into separate sections. Again, if it's only to certain plans, and if there's a violation, there's a $100 per day excise tax that for most employers, especially those with more than 50, this is not pay or play, it's not employer share responsibility, it's a separate code section. The $100 per day excise tax actually is imposed on the plan sponsor, and that's true even if you have a fully insured plan. So it's important to, regardless of the financing vehicle for your benefits, it's important to understand the rules and ensure that they're being satisfied. Well, how about the individual mandate? We talked a little bit about that earlier. As an employer, you would want to ensure that the coverage you offer will help your employees, your retirees, their dependents satisfy the individual mandate. We all have to have coverage or we're taxed. And this was the big issue a couple years ago when Justice Roberts indicated that this was indeed a tax, therefore it was not unconstitutional. So how do we know? Well, look, it's very simple. Every individual in this country, other than a small handful, will have to have minimum essential coverage in order to satisfy the individual mandate. As an employer, the coverage you offer will qualify as minimum essential coverage if it is a group health plan, meaning it's maintained or established by the employer, provides medical care, and it provides other than accepted benefits. That's the only requirement, folks. Has to be a group health plan and has to provide other than accepted benefits. There's no requirement that it be affordable. There's no requirement that it provide minimum value. In fact, as of today, although this may change in the future, plans out there that are often referred to as skinny plans, plans that provide only recommended preventive treatment services or that have very narrow benefits. Perhaps they don't offer hospitalization or certain other benefits, almost always self-insured. It's the only way you can get away with that. Those would still qualify as minimum essential coverage. The key to understanding what constitutes minimum essential coverage and what doesn't is understanding what's an accepted benefit. Now, folks, this is true regardless of whether it's coverage offered to employees, but even retirees. Retirees have an obligation to satisfy the individual mandate and have minimum essential coverage as well. If they're not Medicare eligible, the coverage you offer them could help them satisfy that if it's minimum essential coverage, if it's a group health plan other than accepted health benefits. So important to keep that in line. How about the exchange? What's important for employers to know as we head into 2015 about the exchange? Well, there's a couple of, I think, misunderstandings about the exchange. And the biggest one is that if I am eligible for coverage provided through my employer or through my spouse's employer, or if I'm enrolled in an employer plan, that I cannot enroll in the exchange, and that's simply not true. Virtually everyone other than prisoners and illegal aliens can enroll in an exchange policy. The question really is not whether you can enroll or whether you're eligible. It's whether you qualify for a subsidy. Now, as employers are starting to plan, especially employers with 50 or more full-time employees, those that are subject to the Employer Shared Responsibility Act, the employees that can qualify for a subsidy and the impact the coverage has on eligibility for that subsidy becomes very important. But even if you're not an employer and subject to the Employer Shared Responsibility requirements, it may be important to you how your coverage impacts an individual's eligibility for that subsidy. In fact, no employer in this country is able to discriminate against an individual who may be eligible for a subsidy in the exchange or the marketplace, I should call it. And so it's important to understand how coverage impacts that. So generally, if my household income is between 100 and 400% of poverty level, I would qualify for a subsidy in the exchange. However, if I am eligible for coverage through an eligible employer-sponsored plan, basically a plan that employer plan that is minimum essential coverage, that is affordable and provides minimum value, then it will disqualify me from a subsidy in the exchange. Now, this is true regardless of whether you're full-time, part-time. If I'm an employee being merely eligible for affordable minimum value coverage, and in fact, if I'm a spouse of an employee who's eligible for affordable minimum value coverage, and I'm eligible for that plan, I'm disqualified as a spouse from a subsidy by simply being merely eligible for that plan. In addition, if the coverage does not provide minimum value or is not affordable, but I enroll in it and it's minimum essential coverage, I cannot receive a subsidy with respect to any coverage I have in the exchange. If I'm a former employee, a retiree, an employee's terminated employment who may be eligible for COBRA, being merely eligible for affordable minimum value coverage doesn't disqualify me from a subsidy, but enrolling in coverage does. So here's how this works. If you're an active employee and you are offering affordable minimum value coverage to your employees, whether they be part-time or full-time, they will not be eligible for a subsidy in the exchange. So I'm a part-time employee. You've offered me very cheap coverage. It provides minimum value. I don't enroll in your coverage. I go to the exchange thinking because of my lower income that I may qualify for a subsidy. I wouldn't. Likewise, I'm a retiree, and you are giving me, let's say, for example, HRA coverage. HRA coverage is a group health plan. It does not typically provide minimum value, and it is not an accepted benefit. So if you are automatically giving a retiree coverage that reimburses medical expenses, they would not qualify for a subsidy in the exchange. And I'm talking about pre-Medicare eligible retirees. And so it's important to understand the impact of that coverage. In fact, at least for employees, you could not force coverage on me that was not affordable or didn't provide minimum value. You'd have to give me the opportunity to opt out. That actually is another law under the Affordable Care Act. So that's how the exchange is important. We also have PCORI and transitional reinsurance fees. Now, I'm not going to spend a lot of time on these, except to say just a few points. First, we now have the new PCORI fee for plan years beginning on or after October 1, 2014 and ending before October 1, 2015. It's $2.08. It's gone up 8 cents. And you need to understand that between the PCORI fee and the transitional reinsurance fee, while you use similar methods to determine the average number of covered lives, the scope of individuals you're counting is much different. On the PCORI side, if you maintain a self-insured plan as an employer, you're picking up everybody unless the benefit is an accepted benefit. So you're picking up coverage for retirees. You're picking up coverage, self-insured coverage for your active employees. In fact, you'd even pick up, if you had a fully insured major medical plan but a self-insured HRA, you would actually be required to pay the PCORI fee for individuals covered under that self-insured HRA. However, on the transitional reinsurance side, the scope is much different. We only care about plans that provide minimum value or that aren't supplemental in nature. So I don't have to worry about retirees that are covered under a Medicare plan where Medicare is primary. So I have retiree health coverage, Medicare is primary. I don't have to worry about them. I don't have to worry about HRAs. They're not going to satisfy minimum value, and so even if they're integrated with another plan, I don't have to pay for those individuals. So the point here is understand the differences between the two in order to pay the right, so you don't overpay or don't underpay. The Cadillac tax in 2018 is another one that a lot of folks are starting to get concerned about, and the key here is there's a 40% excise tax imposed on the coverage provider. So if you're fully insured, it'll be on the carrier. If you're self-insured, the plan sponsor will pay it. On the excess of the value of coverage, not just what you charge employees, but the total value of coverage over these thresholds that I have on this slide. Now, these thresholds seem high. They certainly do to me. You're talking a total value of family coverage of $27,500. Think about that. For today's standards, think about what your annual COBRA cost is for family coverage. Probably doesn't get near $27,500, but these amounts are not indexed for inflation before 2019. And so as we hit 2018, when this rule goes into effect, these thresholds may not be near as high as they might seem. I do want to talk a little bit about the employer shared responsibility requirements, and just to raise some points. These, again, for most will go into effect next year. There is some transition relief from the excise taxes for applicable large employers what we call small applicable large employers, those that had between 50 and 99 full-time equivalents in 2014 and meet all of these other requirements I have on the screen. They get an exemption from excise taxes in 2015 for failing to offer coverage to a full-time employee who receives a subsidy in the exchange, but not from the reporting that goes along with the 4980H, pay or play, or employer shared responsibility requirements, whatever it is you want to call it. Determining applicable, now these rules only apply to applicable large employers, and you determine applicable large employer status based on the control group as a whole. If I own 80% or more of Company B, then the control group would include the employees of Company B and my company, and I would determine ALE, applicable large employer status, from that. But once you are an applicable large employer, each individual subsidiary of that control group, each member of that control group is responsible for compliance with 4980H. And the way the rules work, they work like this. You could be subject to an excise tax for each month. I keep seeing these referred to in annual dollars, but they will be imposed for each month that the applicable large employer member, the member of the control group, fails to offer qualifying coverage to a full-time employee, an employee who qualifies as a full-time employee for that month, if that employee goes to the exchange and receives a subsidy for that month. So it's triggered only with respect to full-time employees who receive a subsidy in the exchange. So one of the keys is trying to figure out who is a full-time employee, and I think this is where a lot of employers are struggling. If you look at the statute, you average 30 hours of service per week in a month. Very difficult for employers to monitor that and ensure that if you did average that, you were offered coverage for that month, especially where you have employees that are intermittent and all over the board during the year. So they've given us a couple of different methods, a look-back measurement method and a monthly measurement. And the look-back measurement is extremely complex and complicated, but it does give employers the ability to average hours over a measurement period to determine whether someone is full-time or not. And if they average the requisite hours, you treat them as full-time for an entire stability period, and you would offer coverage if you wanted to avoid excise taxes for each month during that period, regardless of how many hours of service they actually had during the months of that stability period. I'm not going to get into all that detail today, but I do want to talk about how the excise taxes are imposed, because I think there's a lot of confusion over this as well. You look at the statute and it says, hey, look, there's this big, huge excise tax that's assessed if you don't offer coverage. And then there's this smaller excise tax per full-time employee that's imposed if you do, but the coverage is not affordable. Well, you can't, the way the regulations have done this, you can't do it that way. So what I want to do is kind of give you, I call it the bucket method on how to approach how the excise tax is applied. And you look at it for each month of the year. I'm not going to look at this annually. If you look at it annually, you're going to miss some design opportunities that I don't want you to miss. All right, so here's how it works. For a month, you will owe no excise taxes under the pay or play rules. You'll owe no excise taxes if you offer coverage through an eligible employer-sponsored plan, meaning a plan that provides other than accepted benefits, that's affordable, meaning it's the premium you charge, your premium for your lowest cost self-only coverage that provides minimum value is less than 9.5% of whatever affordability standard is you're using. And that coverage also provides minimum value. If you offer that kind of coverage and also offers coverage to, if they want it, the opportunity to enroll in coverage for dependent children, if you offer that kind of coverage to 100% of your employees who qualify as full-time for that month, then you'll pay no excise taxes. Alternatively, you'll pay, even if you don't, you'll pay none for a month if you have no full-time employees who receive a subsidy in the exchange. But if you want to control your destiny, offer 100%. But if you're not in that boat, then an excise tax may apply. So trying to figure out which one, and to determine that, you have to figure out which bucket you're in. It's actually quite simple. If there's two buckets, the sledgehammer bucket and the tack hammer bucket. The sledgehammer bucket is a very big penalty, and if you're in the sledgehammer bucket, you could end up paying a lot of excise taxes. And you're in the sledgehammer bucket, and I'll tell you what those excise taxes are in a second. You're in the sledgehammer bucket if you fail to offer coverage through an eligible employer-sponsored plan that provides minimum essential coverage, to at least 95% of your full-time employees and their dependent children. You have to give them the opportunity, if they want it, to have coverage for dependent children as well. Not just dependent children, but I can enroll myself and my dependent children if I want to. If you meet, and it doesn't have to be affordable, doesn't have to provide minimum value, but if you fail to meet that 95% standard, 70% for 2015, but generally it'll be 95%. If you fail to meet that standard for that month, you are in the sledgehammer bucket. And here's what that means. If one full-time employee goes to the exchange and receives a subsidy for that month, then you pay an excise tax equal to $167, that's 1/12 of 2,000, times the total number of full-time employees for that control group member, reduced by that member's allocable share of 30. I'm not going to get into all those, and it actually ends up being 80 for 2015, so there's some transition relief. But that's a pretty hefty penalty, and that's true even if it's you pay that excise tax on full-time employees even if you offered them coverage or they're enrolled. So let me tell you how this works. And the reason that someone receives a subsidy in exchange isn't relevant. If you're in that bucket, that's the excise tax you pay. So here's how it works. I offer minimum essential coverage to 90% of my full-time employees. I don't offer it to 10%. But one of the 90 that I actually offer coverage to receives a subsidy in the exchange because the coverage I offered either didn't provide minimum value or it wasn't affordable, and I think that's the trap a lot will fall into. It doesn't matter that I offered this person coverage and that's the reason but it wasn't affordable and that's the reason they received a subsidy in the exchange, even if they're the only one. I'm in the sledgehammer bucket. And so I will pay an excise tax of $167 times all of my full-time employees, reduced by my allocable share of 30, 80 if it's 2015. On the other hand, if I've met that 95% threshold, but I'm not at the 100% threshold, then I'm in what we call the tack hammer bucket. And it's understanding this that really helps you design your approach going forward. If I'm in the tack hammer bucket, meaning I met the 95% threshold, but not the 100% threshold that we talked about earlier, and one full-time employee goes to the exchange and receives a subsidy, then I pay $250 for that month times that employee. Now, if you understand how these taxes work and understand your employee population, then you have a better grasp of what to do going forward. The approach to take is this. This is not a mandate to provide coverage, and in some situations, paying an excise tax might be better than offering coverage. For example, we have lots of clients who have historically only offered coverage to full-time employees, and let's say they're fine defining that as 30 hours or more per week. They have a part-time population, whether it might be small, it might be large, it's not relevant. But when we would help them understand how to approach 2015, we would first help them understand these excise tax buckets. Meaning you got to know which one you're in, and you have to understand that these are assessed monthly. And then we would ask, okay, so you're offering coverage to everybody you expect will have average 30 hours of service or more per week. But what about those part-time employees? Do you have any that in any given month might actually be full-time? They might actually have the requisite hours of service. What we would find is you'd be in one of two camps. You'd have an employer that might have a handful of part-time employees in any given month that would average 30 hours of service or more. It might be a busy time of the year, and they might average, they just work a few more hours, but they're still not full-time by your designation. So they have a handful of employees. Let's just say 5. That's an easy number for me. And that these employees might only be full-time for 2-3 months during the year. So we'll just say 3. And so they would start to look at, oh gosh, we've got to do all this stuff to, track their hours of service, and then if they have enough, offer them coverage, and that's going to be expensive. And so we did the math. So we said, hey, let's figure out which excise tax bucket you're in, and as long as you're not in the sledgehammer bucket, let's assume that all 5 go to the exchange and receive a subsidy. You would pay for a month 5 times $250. So your excise tax for a month would be $1,250. Now, let's say that at most they're full-time for 3 months. I'm going to multiply that by 3. My excise tax for the year would be $3,750. That's it. Now, the clients were able to make better decisions because they understood which bucket they were in and how to be in a particular bucket, and they knew that this was assessed monthly. When you know that your penalty is going to be, $3,750 or $4,000, you just pay that. You don't worry about offering coverage in that situation. On the other hand, we had employers in other camps that said, oh my gosh, we've got 10,000 part-time employees that might be full-time in any given month. Well, then you start to do the math on that, and the scales tip to the other side. So if you understand those concepts, then I think you're in a really good position to address pay or play or 4988s. And I'm going to skip over some slides here because I want to get to a topic that apparently, especially going into 2015, has been very hot, very controversial, and that is the impact of IRS Notice 2013-54. Now, this is one of those where I have to say don't shoot the messenger. I actually have an office in D.C. I spend a lot of time with IRS folks, and so I've had I don't know how many, too many to count, conversations about what they intended with respect to this rather convoluted piece of guidance. But I've titled it A New World Order Begins. And this actually affected 14, but I think people are just still digesting it, and so it really has an impact on 15. So here's 2013-54 affects the following arrangements adversely. Okay? If you as an employer or your client as an employer makes a defined contribution plan health plan available, or provides a set amount of dollars per year that an employee can use to purchase major medical coverage on the individual market, and those dollars are tax-free, and in some cases even after-tax dollars. But let's focus on at least the pre-tax for right now. Or if you give me the opportunity to pay for those premiums with pre-tax salary reductions through the cafeteria plan, either of those arrangements for active employees will trigger an excise tax of $100 per day per affected individual. So we're talking about arrangements that, and the way I define it is arrangements that facilitate the payment or reimbursement of premium of an active employee's premiums for major medical coverage in the individual market. Typically it's pre-tax, although some even after-tax payments can be a problem. Arrangements that are not affected are arrangements that pay for accepted benefits, including premiums for policies that provide accepted benefits, as well as plans, defined contribution arrangements that are limited to former employees. And that's the reason why we have this scope, is because 2013-54 addresses one of the rules in the health insurance reform. So let me repeat this because it's important before we go to the next slide. Arrangements that are affected would be any arrangement that facilitates the payment or reimbursement, just facilitates the pre-tax payment or reimbursement of a premium for major medical coverage issued in the individual market, inside or outside the exchange, it doesn't matter. If you have an arrangement that facilitates the payment or pre-tax payment or reimbursement of a premium, an active employee's premium for major medical coverage in the individual market, there's an issue. There's a potential excise tax. If it's for a former employee or if it's for accepted benefits, not a problem. Now, let me get you really to how they got here and what the issue is. So the IRS and the agencies, Department of Labor, Health and Human Services, did not want employers pushing employees into the individual market because pushing more and more unhealthy folks than what they were already required to cover would cause rates to go up. And there are risk corridor and reinsurance payments that were all calculated and determined without consideration of employees of employers going to the individual market. And so the agencies had to find a way to try and stop that. Now, they couldn't remove, because they didn't have the authority to do it, to remove the tax exclusion that's otherwise available. So even after 2013-54, an employer arrangement that facilitates that pre-tax payment of a premium in the individual market isn't included in income. It's still subject to the income tax exclusion. Still subject to the income tax exclusion. However, it raises issues with one of the health insurance reforms, and that is the prohibition on annual dollar limits on essential health benefits. Now, here's how they got here. The way they did this was they said, look, that arrangement that facilitates the pre-tax payment of those premiums is in and of itself a group health plan. And because it's a group health plan, it will be subject to the health insurance reforms, including the prohibition on annual dollar limits, if it's not an accepted benefit, and it wouldn't be. It doesn't fit into any of the accepted benefit categories. And it provides essential health benefits and is not otherwise subject to an exclusion from this rule. All right. So they treated it as a group health plan because it's a group health plan in and of itself. It would be subject to these requirements. And so unless there's an exception that applies or you don't have essential health benefits, we've got a problem because these limit the amount of payments or reimbursements that are being used under the plan. So if you have an arrangement that facilitates the payment of premiums, the amount you pay for premiums would be a defined contribution amount. Premiums are defined. So you have a defined contribution arrangement. It would have an annual limit on those benefits. What they said was if the policy for which you are paying the premiums provides essential health benefits, then we're going to treat the benefit from this payment or reimbursement arrangement, the payment or reimbursement of the premium, as an essential health benefit. So now we know we have a group health plan that provides essential health benefits. And because it provides essential health benefits, I can't have an annual dollar limit on it unless I can fit into one of the exceptions from this rule, for which there were two. One of which is if it's integrated, if the arrangement's integrated with a plan, a group health plan that satisfies the requirements on its own, meaning your arrangement might have a limitation, but once you get to it's integrated with another plan and it provides unlimited amounts on essential health benefits, then you're okay. But what they said was you cannot integrate with an individual market policy. So they cut that out, that one exclusion. The other was if you are a health flexible spending arrangement. Now, the definition of health flexible spending arrangement is broader by definition than health FSAs offered under a cafeteria plan. It would include things like an HRA, or just your garden variety medical expense reimbursement arrangement. What they said in this guidance was, no, what we want to do is limit that exception to health FSAs offered through a cafeteria plan. Well, health FSAs offered through a cafeteria plan, while they can reimburse most medical expenses, there are two that they can't: qualified long-term care services and insurance premiums. And so that is how they went about basically saying, look, we don't want you reimbursing premiums in the individual market. And if you do, you're going to violate this rule for which there's a $100 per day excise tax. And that gets pretty sticky when you start to think about how that can rack up. In fact, they issued an FAQ shortly after this that gave an example. One employee offered this type of arrangement would incur a $100 excise tax for every day during the year, and the amount the employer would pay for that one employee would be $36,500 for the year, and that's a non-deductible excise tax. And so these private exchanges, we still continue to see them out there. I don't like this guidance. I had clients that wanted to do private exchanges, but from an individual standpoint, market standpoint, you're just not able to do those. And then, of course, they gave some for just your garden variety HRA or defined contribution reimbursement account. They've given some guidance on how you can have those if they provide other than, say, dental or vision benefits, and they have to be integrated. So if I'm going to have an HRA today, it has to be, for an active employee, it has to be integrated with an employer's major medical plan. So in other words, I cannot have the HRA or the MERP, as they're sometimes called if they don't have a carryover. I can't have that unless I'm also enrolled in an employer's major medical plan. Could be the same employer or an employer of, say, my spouse. Doesn't matter, but I have to also be enrolled in that plan. And then if the HRA reimbursement is broader than just expenses covered by that health plan but for a deductible, then we know that that employer's major medical plan also has to provide minimum value. And so there are some rules for how you can continue to maintain HRAs. They will continue to flourish, I think. There are also issues in this guidance with respect to health FSAs that do not qualify as an accepted benefit. Now, most garden variety health FSAs will qualify as an accepted benefit. And certainly you can think about the ones that you offer because they're employee funded only. So I can only fund it with pre-tax salary reductions. But in order to be an accepted benefit, there are two requirements you have to meet. First is you have to meet the maximum reimbursement requirement, and that requirement is satisfied if you have only pre-tax salary reductions. If an employer is going to make contributions to a health FSA, meaning they're not cashable contributions, you can match. So I could match whatever you put in with salary reductions, or I could put in up to $500 without regard to what you contribute. and still meet that requirement. So if you have wellness programs that put money into a health FSA that allows the employee to contribute additional amounts, as long as what you'll put in, irrespective of their salary reductions, doesn't exceed $500, you'll meet that requirement, and most do. That's typically not the issue. The second requirement is that other major medical coverage has to be available to that employee. That's not an integration standard, but it has to be available to that employee from that employer. Now, here's where that's a problem. A lot of employers are not going to offer major medical coverage to their part-time employees, especially employers who are subject to pay-or-play requirements. They're just not. Yet they have a tendency to say, but we'll let you have a health FSA that will help you pay for expenses in whatever coverage you do purchase that isn't covered by that coverage. The fact that that employer doesn't make major medical plan coverage available to that health FSA participant means that health FSA is not an accepted benefit. And if it's not an accepted benefit, it's subject to all the health insurance reform requirements, including the requirement that you cover preventive care without cost sharing. Well, because there's a limitation on health FSA amounts for salary reductions up to $2,500, you couldn't, in many cases, pay for all recommended preventive treatment services without cost sharing. And so it would actually violate that requirement. And so there is definitely a new world order in terms of how we look at or how we implement defined contribution accounts. Now, I want to hit a couple. We talked about minimum essential coverage earlier, and we hit that pretty hard. So a lot of these slides, I think, really are more for your reading pleasure later, which I'm sure you will sit down tonight with a spouse or a friend and walk through these at your leisure. Yes, I'm delusional. I get that. But I do want to hit a couple of what I think are interesting points. In particular, what are accepted benefits? Because accepted benefits don't qualify as minimum essential coverage. So if that's all you offer me as an employee or even as a retiree, you're not helping me with that coverage satisfy the individual mandate. And I'm not going to walk through these. There are different categories. But I do want to talk a little bit about a new one we received we got guidance 2 weeks ago from the agency's final regs on two different ones, dental and vision and EAPs, employee assistance plans. If you look through these later and you see the various types of accepted benefits, you'll notice that employee assistance plans wouldn't fit into any of those. And so that means if you offered an employee assistance plan, it would be a group health plan in most cases, and that would mean it would have to satisfy all of the health insurance reform requirements. Well, that's not the case if you meet certain requirements. It would be an accepted benefit. They've issued new rules on that. And it would, let me get to that here. It will, there it is. It'll be an accepted benefit so long as it doesn't provide significant benefits in the nature of medical care. I don't know what that means. But it satisfies certain coordination requirements. In particular, that participants cannot be required to exhaust the EAP before the medical plan begins paying. The EAP cannot be limited to participants who are enrolled in major medical coverage, and you cannot have premiums or cost sharing under. And if you meet those requirements, it'll be an accepted benefit. Likewise, they addressed dental and vision, and there had been an issue about whether or not dental or vision could actually stand alone, whether it could be an accepted benefit if you didn't also offer major medical coverage. And then also whether you had to charge an additional premium in order for it to be an accepted benefit. So here's what they basically have said in this guidance. You can have a standalone dental arrangement. So I've got that part-time employee. I want to provide them self-insured dental coverage. I'm not offering them major medical. That's okay. I can satisfy the requirements and I don't have to charge an additional premium as long as I either give them the right to opt out of that coverage if they want, or if I don't give them that option, then it's not administered pursuant to an administrative services only agreement that covers other benefits. So that would mean if that's all you offered was a dental or vision HRA and you didn't offer anything else, then the way we read these rules, that would be okay. And so I think as you move into, and again I have a fair number of slides still going that I did not intend to cover, but they cover other, what about essential health, what are accepted benefits. I talk a little bit about what you hear are skinny plans, plans that provide only recommended preventive care, plans that may not include hospitalization. And again, go back to the definition of minimum essential coverage. It's a group health plan that's not an accepted benefit. And so these skinny plans, that provide only recommended preventive treatment services, they would in fact qualify as minimum essential coverage. And so if I'm enrolled in that, I satisfy the individual mandate. If you're an applicable large employer who's looking only to stay out of the sledgehammer bucket, then you could offer that to 95% of your full-time employees and you'd stay out of that bucket. Now, whether the agencies will continue to permit that or not remains to be seen. There's quite a bit of talk, if you will, about the future of these types of arrangements and whether they'll still qualify as minimum essential coverage. But I do talk about that in these slides. And so with that, I think that covering a lot of ground should help you get ready for 15. And so with that, let me hand it back over for some questions if we have any. Hello? I figured we'd open it up for questions if we have any.
Okay. Actually, we do not have any questions just yet.
Well, let me do this then. Since we don't have questions, we still have about 9 minutes. I don't want to fill air just to fill air, but I do want to hit the pause button and give a little recap about what we talked about today. We talked about a lot of information, but let me kind of give you a bullet point recap so that when you do walk away from this call today, maybe you have a better sense of what 15 and beyond holds. So as you should have done every year, but especially as we go into 15, you have to approach the Affordable Care Act not as a single bill, but as separate independent bills or a bill with many components to it. And I've given you a breakdown of what I think are the components to the Affordable Care Act. And you have to understand the rules for each component because the rules are different and they affect different plans. And so once you know those, then you can get a better handle on the Affordable Care Act as a whole. And we walked through those, health insurance reforms, and the plans to which those apply. We talked about the individual mandate and how that affects employers and ensuring that their employees have minimum essential coverage. And remember, that's nothing but a group health plan that provides other than accepted benefits. Doesn't have to be affordable, doesn't have to provide minimum value. It's just minimum essential coverage, that's it. We talked about the exchange and how being eligible for or enrolled in an employer's plan doesn't affect my ability to enroll in the exchange. It does, however, affect any premium tax credit or premium subsidy for which I would otherwise be eligible. And I think employers need to understand when it adversely affects their eligibility for it, especially with respect to employees that wouldn't trigger an employer shared responsibility tax for the employer, like part-time employees or even retired employees, how the coverage you offer them could affect their subsidy in the exchange. And then we talked about the employer shared responsibility requirements. We talked about the fees, the PCORI and the transitional reinsurance fee, and the key to understanding those is to understand the scope of plans to which they apply so that you get the right count for your average covered lives, and they're not the same under those two different sets of rules. Then we talked about the Employer Shared Responsibility Act, and the key there is knowing that there is no mandate. It doesn't mandate that you provide coverage. It imposes an excise tax if you don't. There's no individual right of coverage under that code section 4980H. And understanding that each control group member is responsible for compliance, meaning calculating the excise taxes that they owe based on their own full-time employees, and that assessment is done monthly, not annually. Yes, there is an annual fee, but you're taking 1/12 of that and applying it to each month. And understanding which excise tax bucket you're in and understanding how to, say, get into the tax hammer bucket and understanding that these are assessed monthly will help you have a better handle on the design going forward. We talked about Notice 2013-54, and it's a convoluted piece of guidance. It's not viewed favorably by a lot of folks in the benefits industry, but it is what it is. And if you have any arrangement that facilitates the pre-tax payment or reimbursement of an individual market major medical plan, whether it's inside the exchange or outside the exchange, you could have excise tax issues. And that was on purpose, by design from the agencies, in particular, I think, the IRS. And then we talked about the various, what I like to call the mystery of minimum essential coverage, and in particular, the new accepted benefit rules. And I think if you can get a handle on all of that, that's a lot of stuff. Some of these are 4 or 5 hour presentations on their own. But if you can get a handle on all those, then I think moving forward into 15 will be a little bit easier, I think. And so with that, I will hand it back over, and I will now be quiet.
Thank you. Yes, we do have a couple questions. First one, for 2015, if you remain under 50 employees, including full-time employees, the excise taxes do not apply, correct?
Okay, so I love this question because it underscores the very first thing we talked about, and that is understanding the various components. There are many different types of excise taxes that are imposed under the code, under the Affordable Care Act. So you would not be subject to the employer shared responsibility excise taxes if you have less than 50 full-time equivalents. Now remember, that's determined on a control group basis. So you might have 30, but if you are in a control group with another employer that had 20 or more, then you would be an applicable large employer. So you have to keep that in mind. But you wouldn't be subject to those, but you could be subject to other types of excise taxes. So for example, generally speaking, if you have under 50 and you're fully insured and there is a violation of one of the health insurance reforms, so let's say that the policy that covers your employees fails to satisfy the out-of-pocket maximum requirement, that's a violation that's inherent in the policy itself, and because you're an employer under 50, you wouldn't be liable for that excise tax. However, if you had a waiting period that you imposed that was longer than 90 days, or once the fully insured non-discrimination rules go into effect, if you violate that, because that's not inherent in the policy, you would actually be liable for the excise taxes under Code Section 4980D, a totally different excise tax. And so you have to understand what excise taxes you're referring to when you start talking about size.
Okay, thank you. Next question. Outside premium reimbursement for individual plans, plus employer also offers group health plan. Does the existence of the outside premium reimbursement create a taxable event?
No. And let's go back to 2013-54. They did not address, attack, change the tax exclusion otherwise available to employer-paid coverage. Code Section 106 still exists. It's in full force today. If you as an employer said to an employee, I will pay or reimburse your premium for major medical coverage that you purchase in the individual market, that payment you make, that reimbursement, will be tax-free. The problem is, once you do that, you have violated Section 2711 of the Public Health Service Act, which is the prohibition against annual dollar limits on essential health benefits, because that arrangement that you have set up to pay or reimburse that employee's premiums is in and of itself a group health plan, as they see it. And because the policy for which you are paying or reimbursing the premium provides essential health benefits, then the benefit under your arrangement is an essential health benefit. And whether you are saying, I will give you X amount of dollars per year, or you just simply say, I'll reimburse the premiums, they view it as a defined contribution, which means there's an annual dollar limit on it. And now that you've got an annual dollar limit on it, you now have an annual dollar limit on an essential health benefit, which is prohibited by those rules. And there's not an applicable exception here. And so you run afoul of that requirement, and that would subject you to, and I think this goes back to the first person's question about which do the excise taxes apply. If you have 4 employees and you do this, you would pay $100 per day excise tax for all of the employees that you offered that arrangement to. And so even with a small number of employees, it can get pretty expensive.
Okay, thank you, Ashley. We would like to take this opportunity to thank our speaker and our session participants for joining us today. We will be sending a follow-up feedback form at the conclusion of this event and would love to receive any feedback which you would like to share. If If you haven't already, please be sure to join our LinkedIn group where you can post questions, start discussions, and suggest topics for future events. This now concludes our webinar.